this is Human Law, and I'm Star Swift. I'm a professor of Business 201. You guys want to introduce each other?
Sure. My name is Pradeep Charath.
My name is Tori Nageotte.
And what we're going to do today is we're going to discuss the Riley case. You ready for that, Tori?
Absolutely.
Excellent. Why don't you start out with the facts?
So on August 22nd, 2009, the police pulled over David Riley for driving with an expired license plate, and they then impounded his car. And after searching his car, they found 2 guns in his vehicle and arrested him for possession of firearms. And upon his arrest, the police then searched his pockets and found his cell phone, to which they searched and found that he was involved in a gang shooting that had occurred 2 weeks prior, and charged him with attempted murder, assault, and shooting at an occupied vehicle, and he was sentenced to 15 years in prison.
Let me ask you this. Where did they find the phone?
They found it in his pocket when they were searching him before they arrested him for possession of firearms.
Okay, and did he have a password? Was it password protected? Or?
No, it was not.
Okay, thank you.
And in 2014, the case was then brought to the Supreme Court on the basis that the evidence from the phone was illegally obtained because they did not have a warrant for it. And the Supreme Court ruled in 9-0 in favor of Riley, saying that cell phones are protected by the Fourth Amendment and that police need a warrant to search them. And so this case really set a standard for government entities and a standard in the Constitution for how to deal with searching phones, and that is protected, but it's not necessarily, there's not really a standard that's set yet for private entities and different businesses, because it really depends on the specific situation and the clarity of the employee monitoring policy.
All right, so you have a situation where the police have this evidence, and this evidence leads to his conviction. Is that correct?
Yes.
So that's important because that's called the fruit of the poisonous tree. It means that they got the evidence, but not in a legal way. And so the fruit that they got from the search is poisonous, and they can't use it in a conviction. Yet you told me before we started this that, in fact, he served time, didn't he?
Yes, he's still serving his 15-year sentence.
Okay. So, but what we get from this case is that a public entity like the police, like fire department, school districts, etc., that if they violate somebody's constitutional rights, the individual can bring a claim against them, which in this case would be the Fourth Amendment, right?
Yes.
All right. Prohibits illegal searches and seizures. And then you breached on the subject of private entities, which you can't sue for constitutional violations. Could you bring a tort claim against a private employer like GM or Ford?
You could say that it's an invasion of privacy if they search your phone without permission, or on the opposite side, if they feel that an employee is taking pictures of secret, like company secrets, they could bring about a claim of theft of trade secrets.
All right, but then they would have to contact the police,
yes,
who would then get a search warrant.
Then it would become part of the constitutional Fourth Amendment.
Okay, good. Now, as far as the private company, you mentioned a monitoring policy. What's the purpose of a monitoring policy when you're monitoring employees?
So a monitoring policy is kind of monitoring company software and computers to ensure that everyone's being productive and not doing anything they're not supposed to with company material and company time.
Okay. Is there a way, let's say that you turn to someone and you say, oh, that's your private phone, but we don't want you to leave it. We don't want you to take it. We want to be able to go through it. And the employee says, well, no, you're going to have to get a warrant for that. And they say, well, will you let us hold on to it till we get a warrant? And the employee says, okay. How do you protect that phone from not having some kind of distant hacking into the phone?
So they actually have these really inexpensive bags called Faraday bags, and they're foil-lined bags that you place phones in order to prevent any tampering with any of the information that's on the phone.
Okay, so if we looked at Riley, they could have put the phone into a Faraday bag and waited for the search warrant, and that way the evidence couldn't have been destroyed.
Yes.
All right. But in the private sector, you'd have to get the permission of the employee in order to, you'd have to get them to give you the phone, wouldn't you?
Yes.
If the employee says no and starts to walk out the door with the information, is there anything you can do?
I don't think you can in the moment, but I think that later you can contact the police if you believe that there is a case that can be brought against it, but you can't withhold them.
Okay, so you can't, because you worry about then that you're perhaps there's a false arrest or false imprisonment claim in torts as well, right?
Yes.
So in the private sector, you're going to be looking more at perhaps a violation of tort, whereas in the public sector, you'll be looking at the constitutional claims.
Absolutely.
Okay, thank you very much.
Thank you.